So I have an important update in the Suppressor Freedom lawsuit, which aims to remove a state's ban on the purchase and possession of suppressors. So let's talk about what just happened. But real quick before we jump into this video, if you think suppressor bans and regulations on them is clearly a violation of the Second Amendment, go ahead and hit that like button and subscribe. Also want to mention one of the sponsors of the channel, which is Blackout Coffee. They have amazing coffee, they're huge Second Amendment supporters, so if you want to get great coffee and support the 2A cause, I highly recommend them. Check out the links down below and use the code ARMSCHOLAR for 10% off of your order. Also, I just want to mention once again that the Gundies Awards are now open. You can vote for me and a bunch of other creators using the links down below. I'm nominated in Top 2A Voices and then also Influencer of the Year. So again, you can vote every single day. Voting ends on December 15th, so get in those votes early and often. And regardless, thank you guys so much for all of your support. So as I mentioned in the intro, in this video, we're going to be discussing two lawsuits which aim to remove a state ban on the purchase and possession of suppressors. The cases we're going to be talking about in this video are Morris v. Raoul and then also Anderson v. Raoul. These two lawsuits are filed in a federal district court in Illinois, and they aim to remove the state ban on the purchase and possession of suppressors. These lawsuits are important because although 42 states permit the ownership of suppressors, there are 9 jurisdictions within the US that do not. Again, one of those states being Illinois, and then my own state, which is California, which has a ban on NFA items like suppressors. These two lawsuits in Illinois could be the first in the nation which find that a state's outright ban on NFA items like suppressors is in fact unconstitutional. However, in this case, the state of Illinois is trying to have the case completely thrown out by arguing that suppressors are not arms and therefore they are not protected by the Second Amendment at all. And based on this, the state of Illinois is requesting that the judge in the case grant a judgment on the pleadings in the state's favor and completely throw the case out because they argued there is no position that the plaintiffs could bring to show that suppressors are arms and therefore protected. But a recent Pro 2A decision in California, 2 cases are now going to impact what's happening in Illinois with their suppressor lawsuit. The plaintiffs have submitted Judge Benitez's decisions in Miller v. Bonta and Duncan v. Bonta as support to why this case in Illinois is valid and should not be thrown out. In the Anderson lawsuit, the plaintiff stated that the suppressors at issue in this case are bearable arms in common use for lawful purposes that law-abiding people possess by the millions. They are therefore neither dangerous nor unusual and cannot be banned. This is important because it's well established now that modern arms are in fact protected under the Second Amendment, not just muskets like you hear a lot of the anti-gun side try to argue. In fact, the Supreme Court reiterated that very fact in Bruin. The Supreme Court stated in Bruin that we have already recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century. Just as the Second Amendment protects modern forms of communications and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. So the argument that Illinois is making that suppressors are not protected since they did not exist at the time of the founding is completely irrelevant. The Supreme Court has rejected those types of arguments in Heller and Bruin, but they are still trying to use that argument to get this case thrown out. The plaintiffs in both of these cases argue that a suppressor is not dangerous and unusual, and the mere ownership of a suppressor cannot constitute the ownership of a dangerous and unusual item. Instead, these are common arms owned by law-abiding people for lawful purposes. And now, the state of Illinois has filed a motion for a judgment on the pleadings. The entire motion is based on the state's argument that these cases should be thrown out because suppressors are not arms protected by the text of the Second Amendment. Now, for those not familiar, a motion for a judgment on the pleadings is a motion made under the Federal Rules of Civil Procedure. It's a 12C motion. It is used to attack the sufficiency of an opponent's pleadings and the viability of their underlying claims prior to a trial. So it's a motion that it's made prior to a full hearing, and the aim is to completely get the case thrown out. When a court reviews these types of motions, they are limited only to the contents of the party's pleadings and those documents that they attach to those pleadings. If a party wins the motion, then the claims are dismissed by the court and often can prevent a new lawsuit on the same type of claim from being brought. So there is a lot at stake with these types of motions. So the state of Illinois is trying to get the suppressor lawsuit thrown out and prevent any future challenges. Now, in their motion, Illinois argues that plaintiffs raise a Second Amendment challenge to an Illinois law prohibiting the possession of silencers which are attached to firearms to reduce the noise of gunfire. But the Second Amendment protects only the right of the people to keep and bear arms. Silencers are not weapons. They are not used for self-defense, and they are not necessary to the effective use of a firearm. So they are not arms within the meaning of the constitutional text, and thus plaintiffs cannot prevail on their Second Amendment claim. So that is what Illinois is arguing in their motion for judgment on the pleadings to have this case thrown out. They go on to argue that silencers are therefore not arms within the original meaning of the constitutional text. Silencers do not satisfy this definition of arms. A silencer is a firearm accessory. It's not a weapon in itself, nor is it an armor of defense. So that's the state's primary argument, that a suppressor cannot be considered an arm under the Second Amendment. It's not considered an arm under the text. It's not an actual firearm. It's not used to projectile. It's not a weapon in its own right. It's not used to strike at someone, and therefore it's not protected. They believe a suppressor is simply an accessory that cannot be protected under the Second Amendment. Now, two things on this point. First, the state wants to discard all the other laws, including the NFA itself, which defines and treats a suppressor as an actual firearm and an actual weapon in its own right. So you have an overarching federal law passed by Congress, which is treating these items as firearms and weapons in their own right, but the state of Illinois just wants to completely disregard that. They say ignore that, it doesn't matter. Second, they tried to position the Second Amendment and the protection of arms as only actual guns or firearms, when it just says arms, and then that includes all types of other items, magazines, optics, sights, all types of other things could be protected as arms. The state also makes a blanket claim that suppressors are not used for self-defense. Now, I know plenty of people who own and have suppressors on their home defense rifles. A lot of people use them for self-defense. So that is just a blanket statement that they are using that is not protected by any true fact at all. Also, self-defense is not the only conduct protected by the Second Amendment. Self-defense is important, but the Second Amendment also ensures that the people have all arms necessary to protect themselves against a tyrannical government, both foreign and domestic. It's also useful for things like hunting, training, target shooting. So there's a lot of other conduct that is protected by the Second Amendment, not just self-defense. But now the state of Illinois has hit a major roadblock in their arguments that this case should be dismissed and thrown out. Many of you are familiar with the Miller v. Bonta California assault weapon ban case, and then also the Duncan v. Bonta California magazine ban case. Recently, Judge Benitez ruled in both of those cases that the California ban on rifles and magazines is in fact unconstitutional. In Miller, the state of California tried to make similar arguments that these types of rifle restrictions, the restrictions on certain rifle accessories and configurations, certain features, did not violate the Second Amendment. They argued because those features and accessories are not arms, and therefore the restriction on them does not violate the Second Amendment. But Judge Benitez ruled that that was incorrect. He found that these types of configurations, these features are arms and therefore protected, and you cannot ban them. California also tried to argue in Duncan that magazines also in their own right are not arms protected by the Second Amendment. They said that you don't have a right to have access to any type of magazine that you want. Again, that type of argument was rejected by Judge Benitez, and now both of those cases are currently up for review in the Ninth Circuit, and there's a lot of shenanigans going on in the Ninth Circuit. But here in this case in Illinois, in this Illinois suppressor case, the plaintiffs have submitted these two cases, Miller and Duncan, to the judge for support for why the court should deny Illinois' motion for judgment on the pleadings and the request to throw this case out. And the judge in this case has accepted those supplemental authorities, so he is taking them into consideration as well in this Illinois suppressor lawsuit. So this is why all 2A cases and all 2A wins in all jurisdictions are very important. A win in California against the magazine ban and the rifle ban is now being used in the support authority, in the support documents to help the Illinois suppressor case and in helping it to try to move forward. Then the potential Illinois suppressor case, if there's a win here, then that decision could also be used and submitted as supplemental authority to maybe try to attack California suppressor ban, or maybe Hawaii suppressor ban, or other types of suppressor bans that are in place. I think this is kind of an open and shut case to reject the state's motion for judgment on the pleadings and to get rid of this case, but we'll have to wait to see what the judge decides to do. But it's a good sign that the judge here is also considering what just happened in Miller and Duncan as support for why he should potentially reject this request by the state of Illinois to throw out the Illinois suppressor case. So a good sign. If we get any more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Also wanted to mention that you might want to double check your subscription because YouTube has been recently unsubscribing people from the channel. I get comments every single day that people are being unsubscribed, or when they check, they've been unsubscribed. So just double check that. And then also make sure you have all notifications turned on. Click the bell icon, turn on all notifications, because that ensures you get these videos when maybe YouTube decides not to send it to you. But regardless, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.